In 1962, roughly 11% of federal civil cases went to trial. By 2019, that number had dropped to less than 1%. In the criminal system, it's even more stark. 98% of federal criminal cases now end in plea bargains. Only 2 to 3% ever see a jury. The Supreme Court said it plainly in 2012. Ours is, for the most part, a system of pleas, not a system of trials. That means the defining skill of a trial lawyer, the ability to stand up and try a case, is being practiced less than at any point in American legal history. In 1997, there were over 20,000 trials in federal district courts. By 2016, that number had fallen to fewer than 12,000, a 43% decline in under 20 years. And federal courts are just the tip. States like Pennsylvania, Texas, and New York have trial rates below 3%. In one Arizona county, there were 0 criminal trials for 3 consecutive years. Not a single one. Before the 1960s, between 1/4 and 1/3 of state felony charges actually went to trial. Today, it's about 1 in 20. The biggest driver is plea bargaining. What started as an exception has become the system itself. In 1984, 84% of federal cases ended in pleas. By 2001, it was 94%. Today, it hovers near 98%. The math is straightforward. Defendants who go to trial and lose face sentences 3 to 10 times higher than what they'd receive through a plea. That gap, known as the trial penalty, is so coercive that even innocent defendants plead guilty. The Innocence Project has documented dozens of cases. Plea bargains aren't the only force. Diversion programs, drug courts, and pretrial resolution programs are pulling cases out of the courtroom entirely. These programs serve important goals, but they have a secondary effect that nobody talks about. They eliminate the low-stakes cases where new attorneys used to get their first courtroom reps. A generation ago, a new prosecutor might try a dozen misdemeanors in their first year. Traffic violations, petty theft, simple assault. These were the training ground. Today, many of those cases never reach a courtroom. They're diverted, pled out, or dismissed. The new prosecutor's first trial might be a felony. This skills gap collides with another crisis. Prosecutors are quitting in record numbers, and almost nobody is applying to replace them. In Houston, more than 15% of prosecutor positions are open. In Detroit, the vacancy rate exceeds 20%. In Alameda County, California, 1 in 4 prosecutor positions sits empty. In Miami, a staggering 33% are unfilled. A 2024 survey by the National District Attorneys Association found that 70% of prosecutors are thinking about leaving the profession. In Georgia, the 5-year average turnover rate for assistant district attorneys is 25%. In one recent year, it hit 43%. That means offices are constantly backfilling with inexperienced attorneys who may never have tried a case. Public defenders face the same problem, often worse. Caseloads so crushing that Washington state had to adopt lower limits explicitly to stop defenders from quitting. Multiple states report 1 in 4 defender turnover rates. Federal defender offices face additional budget pressures on top of everything else. The National Association for Public Defense has called training in many defender offices grossly inadequate. When a new defender has 200 open cases and no experienced mentor, trial skills become a luxury they can't afford to develop. Here's what makes this dangerous. Trial skills are perishable. They deteriorate without use, just like any physical skill. A lawyer who hasn't conducted a cross-examination in 2 years will be worse at it than they were. A lawyer who has never done one will be lost. And the downstream effects cascade through the system. Judges see fewer well-tried cases. Juries get less experienced advocates on both sides. Defense attorneys who can't try cases can't credibly threaten trial, which means worse plea deals for their clients. Prosecutors who can't try cases let more cases collapse or settle for outcomes that don't serve justice. In every other high-stakes profession, when organic experience gets scarce, practitioners turn to simulation. Pilots don't wait for emergencies to practice emergency procedures. Surgeons don't learn new techniques on live patients. Athletes don't wait for game day. But lawyers? Lawyers still rely almost entirely on learning by doing, in a system that gives them almost nothing to do. Trial advocacy programs in law school help, but most schools offer them as electives, not requirements. And a semester-long course gives students maybe 1 or 2 simulated trials. The ABA requires 6 credits of experiential learning, but students can fulfill that with clinics, externships, or negotiation courses. Trial advocacy is optional. The answer isn't more lectures. It's high-repetition practice of discrete skills. Cross-examination, direct examination, objections, evidence foundations. Think of it like a sport. A basketball player doesn't just play scrimmages. They shoot free throws. They run passing drills. They isolate one skill and repeat it hundreds of times. The same principle applies to trial skills. You don't need to run a full mock trial to get better at cross-examination. You need to practice asking leading questions, over and over. 5 minutes of focused cross-examination drill is worth more than an hour of reading about technique. Saying things out loud changes how your brain processes them. This is the deliberate practice model that researchers have studied for decades. Isolated skills, immediate feedback, high repetition, gradual difficulty increase. There are roughly 2,300 prosecutor offices in the United States, employing about 35,000 attorneys, 94 federal districts, hundreds of public defender offices. There are 198 ABA-accredited law schools, enrolling about 120,000 JD students. Over 156,000 small law firms where solo practitioners handle litigation. All of these attorneys need courtroom skills, and the system that used to teach them those skills, actual trials, is disappearing. The vanishing trial isn't just a statistic. It's a training crisis disguised as an efficiency gain. The trial isn't coming back, not to the levels of a generation ago. Plea bargaining and diversion aren't going away. That means the profession has to build a new path to courtroom competence, one that doesn't depend on organic trial reps that no longer exist. It means treating trial skills like what they are: perishable, trainable, and worth investing in, whether you're a law student or a 20-year veteran. The courtroom is going dark, but the skills it requires don't have to. Practice this at trialtutor.com, where you can drill cross-examination, objections, and evidence foundations